All right. Good evening and welcome to our August 19th Legal Contracts and Board Policy Committee meeting. It is 5:39 p.m. and we will start with Section 1, which is previous meeting summary. If anyone would like to review our previous meeting summary, if there are any comments or concerns. While everyone is reviewing it, I will say, as a reminder, we did not have a July meeting, so we did what I think is a really great job of clearing out the entire agenda and passing through everything up through July, and then we have July off, and now we're back in August, and we have a virtually clean agenda that we are starting the new school year with. And there does not appear to be any comments on Section 1, previous meeting summary, so I will move right along. Section 2, policy readings, we do not have any because we cleared it through. Same thing, roundtable discussion, Section 3. And Section 4, policy status review. It has occurred to me that really Section 4 and Section 5, or Section 6, I mean, should always be probably in reverse, because the new business goes into the status review. What we're going to do in discussion next time, what's going into a first reading, what's going to a second reading. We need to know what our new business is first. So this makes more sense. So thank you for this. And thank you for having our agenda posted on time, which is early. So thank you, thank you, thank you. Moving right along, unfinished business. As I stated, we have no unfinished business. And so we are already at 5:41 on new business. And so as you will see in your agendas, we currently have 1, 2, 3, 4, 5. We currently have 5 items in new business, and then we have, it looks like 3 people signed up for public participation, which will be part of our new business, and I will read our statement and everything as part of new business. But we will start with Section 601, Policy 8660, Incidental Transportation of Students by Private Vehicle.
Thank you. Haley Kepchar with Retzel and Andrus. So this policy is one that the district is reviewing currently to see how often it is actually used. The purpose of it is to authorize private vehicles for use by the district. While the policy is already on our books, we wanted to provide an update to be in accordance with the NEOLA update.
Okay, thank you. And for those of you with the packet, that is the second item on here. It says, I guess they all start volume 40, so 8660. And it looks to me that there's one sentence that has been crossed out and maybe 3 sentences added, and those are the only changes. So if you would like to read, or I could read what that is.
So what has been crossed out of the first paragraph is this includes, after the authorization of the private vehicles, this includes occasional transportation for field trips, outings, and the like. That's now been removed. And additionally, language has been added that says routine and non-routine transportation, however, shall be subject to all requirements listed in AC 3301-83-19. Board Policy 8600, Transportation Board Policy 8640, Transportation for Non-Routine Trips, Board Policy 8650, Transportation by vehicles other than school buses, and relevant administrative guidelines. There is also the addition of the sentence towards the bottom of the page, which states that expenses incurred by drivers of private vehicles in the course of transporting students will be reimbursed by the board at approved mileage rate and upon presentation of evidence of costs and tolls for parking fees. And then there's some language in the middle that's been changed just to say persons instead of he or she.
Thank you for that update. So just from a lay person's point of view, is that kind of like if I am a parent transporting students for a field trip, is that the last sentence? Expenses incurred by drivers will be reimbursed. That type of scenario, is that what is intended there?
We indicated that.
We can't hear.
Well, we removed the ability for volunteers to transport students in their private vehicles for field trips. That line, so this includes occasional transportation for field trips, outings, and the like. That part has been crossed off. And so it's for, that's what Mr. Deffenbaugh and I were just talking about as it relates to this policy still being here as like the incidental type of transportation. Like it would have to be a really special circumstance that's taking place as it relates to someone being able to transport students in their own private vehicle. Yeah. I don't know, did you want to add anything to that, Mr. Deffenbaugh?
No, the last meeting, I recommended that we were looking at repealing this policy, the current policy, and then we decided as, emergency basis, we didn't want to eliminate that time where it may be needed for band, it may be needed for sports, whether they're going to some recruiting event. So we didn't want to totally limit it and just repeal it. So we're going to go ahead and recommend with the Neola updates. We just took the field trips through, so this will not count field trips. We've limited that. So it's a very narrow exception that we decided to go ahead and recommend passage of this with the updated Neola updates.
Okay. Thank you for those comments, and this is in new business, and I do remember this was one that we had, as we talked, it was kind of lingering in discussion at our last meeting.
That's correct.
Yes, okay. And so we can put this up for a first read for the next legal policy committee meeting. I would ask the other board members, but they are not here. But we will move this through the pipeline. Thank you. Are there any other comments or just things on? Okay. Thank you. Next, I see policy 3120, employment of substitutes.
So our recommendation is to not move forward. This initially came across our desks because it is a Neola update. Our recommendation is not to move forward with changing it because the district is not going to use unlicensed subs on a permanent basis, and those are the subs that don't have bachelor's degrees. So that's the recommendation at this time. You can see in the third paragraph where those changes would be in accordance with the Neola updates. They're pretty minimal. Oh, thank you. Yeah, yes, except for student teaching. Thank you so much.
So to clarify, this is not the Neola update, but this is an update.
No,
it is.
The Neola update as relates to, sorry. This is part of the Neola update as it relates to being able to hire your pre-service teachers. So like those scholars who are in college doing their student teaching with us, they're saying that we could utilize them if we needed to as a substitute, but they would need to have the pre-service teaching permit from the Ohio Department of Education and Workforce. So that would be the only exception as it relates to someone being utilized as a sub without a 4-year degree.
Okay, I was just confused because it says it's being recommended not to proceed with the Neola update, but we did add that Neola update.
Correct. We're recommending at this time not to move forward with an amendment of this policy or use of this policy because there's been change in state law. Based on advice of council, we're reviewing those changes that the legislator just passed. So at this time, yeah, we're asking not to move forward with this. At all.
Okay, so we don't even want to move forward with the pre-service?
No.
So no.
Okay.
So I apologize. I didn't realize that we had come to that final decision as it relates to the pre-service teachers. So then that means no one without a 4-year degree.
Okay. So then no changes to this policy at all?
Correct. We're not moving forward on it.
Correct, at this time.
Okay. So do you want to keep this policy on hold in unfinished business or just kind of out of sight, out of mind?
Unfinished business for right now.
Unfinished business?
Unfinished.
All right, thank you. We can leave this one in unfinished business. And moving on now, policy 5136, personal communication devices.
So this is an amendment to a policy that we have on the books already to reflect legislation that was effective on August 14th of 2024. I believe it's House Bill 214, which bans cell phone use in schools by students. This language was drafted by council in order to make it very clear that even though Akron Public Schools has been had this practice for a while of not using cell phones, not letting students use their cell phones in classes, there's language that has been changed and added to in order to make that clear in accordance with that law. We do think that this should move forward to the board, if possible at this time, in order to be compliant with that. But that being said, the Neola update that will cover this will come towards the end of this month, and then we may be in review of it again. Does that make sense?
So what it sounds like is the request is to fast track this item to next Monday's meeting and then review this item again in a month or two?
Yes, in order to be compliant with state law.
Okay, so the policy that we have currently is not in compliance with state law?
It's just not clear as to the fact that the phones are totally banned. And the practice that APS has right now is compliant.
Right. And we want to also make sure, we want to be in alignment with whatever Neola comes out with, and they're not going to come out until after this week sometime. But we know we need to have a policy in place for once school starts. So that's why we would want to revisit it after we get Neola's recommendation on what the policy should look like. But right now, this is a working policy that we have, that we looked at making some modifications so that, because we know that cell phones are banned and any kind of personal communication devices are banned right now. But we're still waiting for the guidance from Neola as it relates to, you know, writing a policy that encompasses the new law. But we do want to make sure we have a policy in place once school starts.
Okay, so for clarification, this is the policy that is currently in place?
Correct, with a
Correct.
little bit of modifications, like adding in some, so the policy is from 2007, modified in 2015, but since then, there's been other things that have come on the horizon as it relates to Bluetooth glasses, smartwatch, like there's all kind of new technology that we wanted to try to capture within the policy.
So it looks like, just for clarity here, in the policy that is on record currently, our current policy, computers, tablets, iPads, e-readers, cell phones, telephone paging devices, beepers and pages, BlackBerry, iPhone, Android, Windows mobile devices, or web-enabled devices of any type. Those are items on our current policy.
Yes.
Yes.
With some
So-
addition- yeah, some of this stuff
So
is
what is being so this one is the recommended changes, the recommended
Correct.
updates. And so it looks like items have been taken out, or not items, but sentences have been taken out. May not use PCDs on school property or a school-sponsored activity. That information is taken out, but I don't see examples of items. Can you help me that were added in?
if you go down, so they put PCD in, personal communication device, struck out some language because it appears in another board policy for permitted use that the board previously passed. I think what it also does, it makes clear in 4th paragraph down, students are prohibited from using cell phones at all times. The policy applies to the use of cell phones by students while on school property during school hours. Importantly is the next paragraph. That is the exceptions that is contained in the new state law. So for health concerns and also for other accommodations, we've taken that from the House bill and incorporated that into the board policy, so we're state law compliant. So the exceptions is as important as the general rule of no cell phone.
So then from my readings of these, it looks like there are no additional items that are being prohibited, but the new policy actually allows additional use case for cell phones because the old policy did not allow students to use their phone if it's part of their IEP or to monitor health. And so the new policy has everything in the old policy the same, and students can use their phone to monitor health, and they can use their phone as part of an IEP.
Yeah, and it clarifies, if you look at where we struck out, students may use personal communication devices before and after school. Well, that's no longer compliant, so that has been struck. And now we are going to follow state law. Students are prohibited from using cell phones. So that's a bit of a nuanced change. It's now a prohibition on use, whereas before it was they may or may not. So it really clarifies based on the state law, the prohibition, and then incorporates, as you just articulated, the exceptions to the general rule of prohibition.
So it does look like on the current policy, because it's hard to count on the other one. 1, 2, 3, 4, 5. On the 5th paragraph of the current policy, it does say, except as authorized by a teacher, administrator, or IEP team. And so it does look like on the current policy, we do have the IEP exception already there?
Yeah, you do, but you're also having health concern that was passed in the state law. You're also having the Rehabilitation Act, that's an accommodation added into the state law. So this now is reflecting those exceptions in the state law, as well as the prohibition of use of a device in school. So this was designed to really follow and mirror the current state law that was just recently passed. And as council instructed, we're going to come back. Neola hasn't even put out a policy yet, but due to the state law, at the timing of it, we needed to go ahead and address that so we're compliant.
And how does this affect students? I know that, for instance, our early college students need to use their cell phones frequently throughout the day in order to multi-factor authenticate. How is that addressed in this policy?
So
There's a permissible use. A student can use, that's a whole different policy that Mr. Hanshaw presented to the board. They may use it at the teacher's, if a teacher indicates, yes, this is part of the classroom, it can be used, any device.
Okay.
So it's really not bearing upon that. It's just stating that it's prohibited, and then there's the exceptions. And of course, through the permissible use policy, students are able to use technology with, the teacher approving of it.
Okay. So even with this policy, as long as the teacher is acknowledging and approving it, then students can use their device as needed.
For classroom.
For classroom purposes.
Work, yes.
But even without the teacher, they can use it to monitor and address a health concern, which is critical.
Which is critical,
Yes.
was just passed. Yep.
Okay.
Yep, exactly.
Thank you. Well, I do see that this is asked to be moved on to the August 26th meeting. There are no other board members here, but I will do my best to explain these differences. That's why I asked so many questions, so I can try to explain as many of this as I can at the August 26th meeting to suspend the rules. I don't know what will come of that, but we will bring that up.
Thank you very much.
Thank you. Okay. Next item is 604. Neola next update expected August 23.
So I think that this item is on here just as a placeholder and to inform us that we do have in a week or two from now a slew of new updates that are going to come through, and those will reflect, I'm sure, the new legislation that we'll discuss in 6.05.
Okay, thank you. And other than what is in 605, are there additional policies anticipated to be coming to the September meeting as part of the August 23 Neola update, possibly? Is that a possibility?
For the communication device, possibly.
All right. Thank you. And now 605, new laws passed that require updated policies.
Thank you. And to clarify, the cell phone personal communication policy is 250. So now we're going to, I'll briefly discuss House Bill 214, which is effective on October 24th, 2024. And that will require the district to have a policy on matters regarding specific beliefs, affiliations, ideals, or principles, and will require the district to adopt and post a policy against using statements of commitment to or soliciting or requiring specified individuals to ascribe to specific beliefs, affiliations, ideals, or principles, and will also require a policy to accommodate students' held religious beliefs. So the school district will also be required to adopt a policy to reasonably accommodate those sincerely held beliefs and practices for students, which includes permitting up to 3 excused absences for religious expression days.
And are we anticipating to have a draft of what we would like for that as part of a discussion?
We don't have that today, but that'll come with the Neola update.
So then will that be part of our September meeting or after September?
If we get the updates, we're waiting on the updates from the state, but if we get those, then they would be in September. We're hoping that we would get them quickly because we need to do our end, and I think they give us, 90 days?
Yes, sir. My understanding is
yes.
90 days.
That's right. So I'm anticipating it will be in September.
Okay. So can we put a placeholder for our, September 16th meeting at 5:30, a placeholder in the discussion section for House Bill 214?
Yes.
And the next one is Senate Bill 29?
Yes, so Senate Bill 29 is also effective on October 24th, 2024, which imposes new restrictions on data that's collected and stored by districts or their vendors. It will restrict the ability of districts to monitor school-issued devices in most instances. In previous versions, the bill establishes that all data created, collected, and maintained by a district is the property of the district and not the third-party technology provider or vendor. It prohibits the third-party provider or vendor from selling or distributing the data in any way, and imposes a process that needs to be followed should any kind of data breach occur. The process will apply to all breaches, whether or not they are made by the district or by the provider or vendor, and the bill also grants the authority of the State Board of Education to take action against individuals' licenses should they release confidential information.
And you said that is something we have to have done by October?
It's effective October 24th, 2024. And then there's different provisions of the policies that have the 90-day, the 90 days requirements for policy. So that I think is something that will be clarified in Neola as well.
Should we put a place for this in discussion in the September meeting, or because we're doing 214, the September meeting, would you like this in the October meeting? What is the preference?
Well, I think I guess we're kind of waiting on Neola, but if we get it, I would put the placeholder, and then we can always move it, because certain parts of it will have a 90-day kind of deal, waiting time. So to make sure we're in compliance, because if we get it in September, then that would be, October would be, what, 30 days?
That's right.
Yeah, and then, so that would give us a little bit more time, wiggle room with that.
All right.
And I believe actually the 90 days will apply to 214, and for Senate Bill 29, the provisions will be effective immediately. So for that one, we should prioritize having that as a placeholder. And hopefully Neola will give us some guidance as to that, but I'm sure that we'll be able to provide some kind of draft by then with Neola's assistance.
Okay, sorry, I missed that. Which one did you want to prioritize?
I think Senate Bill 29
okay.
should be.
Okay, we can put both placeholders in for the September, and then if you need to remove one, just let us know.
That would be perfect. Thank you.
All right, so that is everything on the listed new business. We do have 3 community members that have signed up for the public participation at board meetings. I do have a statement to read. I know it's hard. This is the contracts committee, so of course people want to discuss contracts, but I will read, participants will not be permitted to speak on matters related to specific vendors or business matters, formal complaints, grievances, specific student or student records, personnel matters, and or pending legal matters. Participants must speak on matters related to the business of the board. Please keep your comments to 3 minutes or less. The board will not respond, but will assign through the superintendent or the appropriate person for follow-up. And so our first person signed up is Pastor Harrison. And when you are ready, I have to open my timer here. There we go. All right.
This is not what I came to speak about, but I do want to mention for the superintendent, the communication policy, one of the things that we may need to consider, because you will have a mass panic of parents if something happens at a school and it gets out somewhere, something happened, the parents may need a way of making sure their kids are safe, because you don't want them all running to the school. So just with that communication, it's something I was thinking when they were going through the governors, all of that. But what I wanted to talk about 2 contracts in particular. I want to talk about the bond issue that built the schools and the fund that's left over, the $16 million that's currently held. I want to know if we can get a copy of the language of that joint board of review. That money is school money, and the city should not be entitled to any portion of that. And I think if we review the how the bond issue was laid out, and what was given to us as citizens with the money, the use for the money, I think we will find that the school nor the city has lived up to that, where we already passed the bond issue to build all of the schools. The next thing is the $5 million. $5 million that the city says that the school board owes for this building. I would like to see that note. I would like to see the agreement before the school starts to pay the city of Akron any money. That agreement needs to be made public, and we need to know what happened to 70 North Broadway. Okay, so the complete picture needs to be drawn before the school starts to pay money out, because you're asking for money. So that $16 million with the joint board of review, that whole bond issue needs to be reviewed. And why we owe the city of Akron $5 million, I would love to see that paperwork and get the official understanding from the school if we owe the money, why we owe the money, and how we'll pay for them. Thank you.
All right, thank you. Next, we have Brandy Vickers. Let me restart the timer here. All right, go ahead.
So I just believe that there should be a process implemented that supports APS vendors and people that are contracted with APS, because right now there is no policy or place that you can go if you have a grievance. And as we can plainly see over the last few months, that as the van drivers were down here, the concerns from the van drivers were obviously valid because you guys listened and made a decision. And so when the proper chain of command is already followed and we still don't get anywhere, that's like, in essence, you're saying we have to be silent because we get 3 minutes here, we're restricted in conversation. And so, and then if we ask for an executive session to try to talk to the board, you know, behind closed doors, we're still told no. So it seems like there is no outlet for vendors. There is no way for us to communicate things when we don't agree with certain things. And I do think that it's very important that we're still able to be heard because we are part of the community. We are voters. We have a say-so. APS parents, I mean, it's a classified group of people that's all part of that. So, you know, because I have questions as well about contracts, and I'd like to know, are administrative fees charged to every vendor? Because we're hearing that within the agreement that the van drivers had, there's an administrative fee that is being charged to them or us, and we have no knowledge about that. So I do believe in contract law that anytime there's any type of fees being charged, it should be exclusively stated, and that's for transparency purposes for everybody involved. And I was quoted by the chief of staff a fee that the van drivers did not see. And the chief of staff said that it was because of administrative fees. So I'm just curious as to how that works. Also, I would be questioning if someone is kind of coming here asking for a raise, then where would it be pay decreases? Because APS is willing to pay businesses like millions of dollars, but then you have the smaller people doing the work and they take pay cuts. So logically, it's not really making sense. I mean, the contract, it's just not clear and outlined. There were things that was represented as state law and mandates in reference to seatbelts. And I'm not sure if that's accurately a law. It's a recommendation based on everything that I've been told. But again, it was represented to drivers as law and not as a recommendation. And I think that you guys already had an issue with laws and mandates being an issue. So I think that just needs to be more transparency in things. Thank you.
All right, thank you. And our third person who signed up is Ms. Jasmine Wadood.
Thank you. So I'm here to basically try and address you guys the proper way and limit my speech, which is exactly why I was requesting the executive session with you guys all together so that we did not have to limit what we could say and how much we could communicate with you guys. We understand that the board has absolutely taken the time to hear us and try and foster some progress for us. We also understand that the administration has been doing some work on their end to try to appease the board as well, but things have still been falling short. And I just want to reiterate that with our contracts, we did everything that we could to try and avoid certain issues that we would need to bring to the administration, to the board, if we get the opportunity to do so. I'm requesting an executive session with all of you to address these things. The administrative fees, things such as, I don't want to use harsh words, but it just felt very unconscionable to me. I felt a bit of duress. I felt confusion. And it would have been nice to have answers before being made to sign or needing to sign or feeling that type of pressure at the day of signing. And that was all we were trying to avoid. So again, we try to be very reasonable, and we're just not finding the same response in return. We're being told things that vendors don't, in our position, don't get to negotiate. That sounds completely against the laws that I know for business. The information that was just shared has not been corrected at all to be made in alignment with certain regulations. We're being told that the district may make laws that supersede the law, that are more strict than the law. But when you're talking about consequences of things like terminating contracts, when there are conflicts of interest there, those should be fully taken into consideration and handled correctly, in my opinion. And this was something, again, that we were hoping to have some transparency with the board as well as with the administration and our colleagues, whether it's every single one of them or representatives, however, but to keep things so divided, it's just not fostering the transparency that the board and that our school district says that we provide. And so I would hope that we could echo some words that we heard in the prior meeting of some sort of committee being formed to oversee these types of things so that vendors can be properly heard and the solutions that are needed can be done before it goes too far. Thank you, guys.
All right. So that is everyone that has signed up. So I have 3 items. I wanted to make sure we had time. 3 items of new business. We recently, as a board, had our own professional development, and in our board's professional development, it was recommended to us to review what we have in writing and also review what we need to have in writing. And there are a lot of things sometimes that can be confusing and can solve confusion based upon what is in writing. And so of the 3 items I have, the first 2 are actually based off of things that I read in the transition report. And so I am requesting the administration to bring what they would like to have in writing around these items. So what is it that we have, and what is it that you think we should have? Because this was brought to my attention, it's something I would like to know about and what it is. So I'm just going to read what the transition report says, which is hopefully helpful. And it says, there are 2 areas that must be addressed. The first is nepotism, and the second is anonymous complaints. The transition report also reads, nepotism is addressed in policy 5120 and 3210. It continues, both prohibit any employee from directly supervising a relative. Relatives are not defined. However, a staff member may supervise an individual who supervises a relative. And so I would like to hear, at the administration's convenience in a discussion section, what you would like to have regarding these items that were brought to our attention. So that is the first 2. And so I don't know if you want to let us know which month or which committee meeting works for that. And then the third one is related to contracts. I do see that we have in our board policies and in our board docs and our laws and bylaws, we have a lot of policies for professional staff. Within professional staff, we have policy 3120 for volunteers. And so we have specified within our policies how we will and will not act around certain groups of people who are involved in our buildings and with our students, employees, subs, volunteers, all kinds of things. I'm curious if there's an opportunity in here to also describe various other types of people who are involved in our schools, like potentially vendors or independent contractors. What is it that we would have on the books for that? Because I know we have recently heard a lot of things about transportation independent contractors, but I know we utilize independent contractors very broadly in many areas throughout our district, in media and lots of other things. But I don't see what we have here. So if the administration could provide us with what they would like to see, I would appreciate that also.
Thank you, Dr. Molinar. I'm not quite sure, perhaps, everything that you're asking. So when you're asking, I guess for clarity's sake, I'm trying to make sure that I understand what it is that you're asking. You're mentioning policy 5120 and 3210, I'm sorry. Around nepotism, and you said something else.
Oh, yes. So these are three separate things. So what is written in the transition report is 1520 and 3120. That's what's written in the transition report.
Oh, 1520 and 3120?
Yes. It's page 56 of the transition report, and I have not had any.
So it's,
Yes.
are you saying 5120 or 15?
Sorry, 1520. I might have inverted that. My bad. Page 56 of the transition report that mentioned those two policies. And it might be something that the administration tells the board we don't need to adjust, we don't need to change, but just to bring to the discussion of our policy committee meeting because it was brought up in the report.
So, okay, I got that. Now what was the first thing that you said?
Yes, so the first one was the nepotism and the second was anonymous complaints, and both of those are page 56. And I will admit that 100% of what I know about either of these is from page 56.
Okay, and 3120 was around, you said volunteers?
No, so the third item is, yes, 312009 is an example of what is written, what we do have a policy on, which is volunteers. We do have a policy on volunteers.
Right.
And so if we could have something potentially specific for,
So you want to know like what's required for instance, we have different mental health agencies. I always forget to push that button.
So you're saying, like, for instance, we have like different mental health agencies that service some of our students and our families within our buildings. You want to know, like, what's the process as it relates to the staff that they may have in our building? Like, how do we know that they have background checks and things like that? Is that what you're referring to? Or
well, and how
clarification?
how we interact with groups of people in our district. So I can read 3120 volunteers just for an example, but it in this section, it talks about volunteers will be asked to sign a form releasing the district of any obligation should the volunteer become ill. So there's a lot of information here specific to the role of a volunteer and the interaction of volunteers. This might not be the best example for this, but it was the closest thing I could find, which told me that there's probably something better that we could do.
Okay.
So
not contracts per se, but just everything around people volunteering.
So 3120 is people volunteering. If we could have and above 3120, which is people volunteering, we have people for co-curricular activities. Above that, we have interns and summer school. So if we could have something that outlines how the district interacts with additional groups of people that are not named, like independent contractors, which we have various forms of independent contractors, or potentially vendors, whatever, how we interact and how the administration would like that to be written for us to interact with other groups of people. That way we have something on the books to reference. And if there's a different placement within board docs that is recommended, that all of this is likely part of the discussion. Any other comments, concerns, questions, new business?
So the transition report, as I had shared before, the transition report, so I had the transition report done as approved by the board to be done. So that the transition report is the report that a superintendent will request of either an agency, someone outside will come in. So these things in terms of nepotism policies, we have discussed, the report was done prior to my coming in for the year before, but we did discuss, I have been in conversation with Mr. Deffenbaugh around policy that addresses nepotism. Because it has not been something that I've had to address this previous year. However, it is still something that I want to make sure that we do have a sound policy around it. So we have been talking about that. And when I guess we are able to, because I'm not sure if we currently have a policy or not, but we have had some discussion, quite extensive discussions around nepotism and how, well, actually, we do have a policy, I'm sorry, that, but there are some things that I think we need to revisit around that policy and ensuring that maybe some things that have been previously done or scenarios that have been previously situated, we may need to go back and revisit what that actually looks like in the day-to-day operation of things. So, yeah, that is something that we definitely have been addressing. And in terms of, I'll take a look at policy 3120 regarding volunteers to kind of get an idea of what it is that you're asking in terms of independent contractors or whatever. I mean, because we deal with them. I know that has kind of been a saturated term used, but we deal with them all the time, not just through our transportation, but through other means as well. And I really don't think that there is anything, at least I've not seen anything in terms of, but we can definitely look at what we currently have and construct something that we can provide to the board for a review.
And even if, thank you for all of this, and even if there isn't, I understand, in 1 month's time, we might not have policies ready for any of these, but if we could just have, I mean, you kind of already did start the discussion, especially by explaining the nepotism and things like that, but just possibly in our September meeting, just give us an update on the conversations you've had so far, and then maybe a timeline of, we'd like to have a policy on nepotism ready to bring to the committee in February or March or something like that. But just very, very brief, because when, as a board member, when we're out in the community, people ask us, and then I would like to be able to say, oh, March or July, or the administration reviewed our current policy and said it's fine for now, but just to have a response ready.
Okay.
So, okay, thank you very much. Looks.
I just want to say, when it airs, we can't hear. So
Okay.
it's not to be rude, but we can't hear because of the speakers. Maybe they can put speakers on the wall or something, but we can't hear you outside.
Okay. All right. Thank you. And so with that, it is 6:30. This is the first time the policy committee has ended early, I think, all year. Oh, but we have not ended early yet because I rearranged this. I'm sorry, Heidi. So things to look forward to. In our 9/16 meeting at 5:30, we have one item that will be in the legal committee for a first reading. That is 8660. Then we have nothing in a second reading. We do have 3 discussions, House Bill 14, Senate Bill 29, and then administrative updates. And then a possible suspend the rules for a third and final reading at Monday, the 26th, on the personal communication devices. Does that sound like what we reviewed?
Yes, it does.
Okay, 6:31, we are adjourned. Thank you.